Thank you, Mr. Chairman. You know, we have these hearings, and I suspect one of the reasons we have these hearings is to try to get some idea of whether or not the rules that are proposed are appropriate. And for that, it would be helpful to have a fairly objective panel here, of good cross-sections of opinions. I'm not sure we have that in this situation. Let me start with you, Mr. Lotito. You don't appear before us, or you don't even purport to appear before us as an uninterested or an unbiased party, do you?
I'm certainly interested.
Right, and you certainly are. So you know, I look at that because I look at your firm's biography of you, and this, you're one of the nation's leading authorities on preventative strategies in the workplace. So those preventative strategies include preventing employees from even organizing as a union or union busting. So I wanted to explore that a little bit. Your firm website has a client advice memo, and its title is "Time is on Your Side." It explains that there are situations when pre-election hearings are to the employer's advantage. Here's what it says, and I quote, "In a recent campaign among 870 registered nurses at South Shore Hospital in Massachusetts, which was represented by Jackson Lewis, a 27-day hearing contributed to the 5-month period between filing the petition and the election," close quote. The memo says nothing about the merits of the hearing. What it does say, and I quote again, is a hearing of some length can put valuable time between the union's moment of maximum support when the election petition is filed and the date of the election, close quote. So it looks to the rest of us here that union-busting firms, like your firm, think a pre-election hearing is more about strategy than it is about substance, and it's doing something other than resolving the material issue. Isn't that correct?
No.
Okay.
First of all, we're not a union-busting law firm.
Okay. In this case,
the vast majority of...
You've answered the question, and I appreciate your comment on that. But
well,
in this case, the hearing, regardless of its outcome, appeared to be pretty good strategy for stopping the organizing drive, because your memo quotes one of the union spokespersons as saying the 5-month delay was a killer. So your biography also says that you helped run the firm's How to Stay Union-Free program, which apparently is some sort of a seminar. In 2007, a reporter named Art Levine apparently went to a union avoidance seminar conducted by you in Las Vegas. It cost him $1,595 to attend. He wrote about it in an article entitled "Union Busting Confidential." And he quotes you, Mr. Lotito, as saying, and I quote, "It's going to cost you some money to remain union-free, sometimes big money." So my question to you is, how much does it cost an employer, or how much does it cost a union, how much does it cost us as taxpayers, when you have a 27-day hearing cost that puts, as was said, valuable time between the petition and the election? What's the cost to the company? What's the cost to the union?
There's a lot of questions there.
Well, no, it's very simple. What's the cost to putting valuable time between a petition election for an employer or for a union?
The vast majority of situations, there is no hearing whatsoever.
Okay.
In the situation, that you're describing, there were obviously very complex issues.
Is what's the cost? Do you have?
I don't know what the cost of that hearing
was. Thank you
for
that. In 2004, the New York Times wrote about another client of yours, a South Carolina battery company called Enersys. In the article, it said Enersys was fighting an organizing drive, but it ended up paying $7.75 million to settle 120 labor law violations. And the company ended up suing your firm, accusing Jackson Lewis, and I quote, of malpractice and of advising it to engage in illegal behavior, close quote. And some of that behavior ostensibly was harassing unions' top officials, improperly withdrawing the union recognition, moving the production to a non-union plant in retaliation. Now, that lawsuit was, as I understand it, settled. Can you share with us what the terms of the settlement were?
No, I can't, because the settlement was confidential.
So do you know whether or not your firm advised a pre-election hearing in that case in order to delay the election so the employer could do a string of actions?
I wasn't involved in that situation, so I don't know if we specifically advised them to have to have a hearing.
Let's turn to another document in your firm then. It's a publication called Union No, K-N-O-W, but the N-O are set off in relief, that an issue dated September 2001. The first article in that is entitled "War is Hell, Full, H-E-L, P-F-U-L. So it leads one to wonder here, you also mentioned in that union avoidance war games. So what war would that be? It would be a war of employers on employees? Is that what exercising rights as a worker should entail, that your employer goes to war with your employees? Creating of conflict in the workplace, part of the union-busting game? When you said in your testimony that you were creating a positive workplace environment, And the whole purpose of the National Labor Relations Board, one of them at least, is to provide a more stable, less conflict-ridden labor relations for both employers and employees, including a free and fair way for workers to decide upon union representation. So having war games and having war be helpful to employers, you tell me how that's creating a positive workplace environment?
The gentleman's time has expired. Dr. Rowe.